Art. This criminal revision has been preferred against the order dated 6/6/2014 passed by the Additional Sessions Judge, Court number 3, Bulandshahr, dismissing Criminal Appeal number 63 of 2014, Shabbir versus State of UP, and the order dated 15/4/2014 passed by the Juvenile Justice Board, Bulandshahr, in bail application number 44 of 2014, whereby the bail application of the revisionist has been rejected. Full stop. Para. Brief facts are that the complainant Salim Khan gave a written report at the police station stating that he is resident of Jatiyan-2, Chhacharai Road, Kasba Jahanagirabad, डिस्ट्रिक्ट बुलंदशहर फुल स्टॉप on 19/10/2013 at 1:30 in the noon, he was going with his wife to leave his nephew at Bulandshahr full stop. On the way, he was informed that Shabana had called the complainant's daughter, namely, Manisha, to her house and had closed her in a room with her brother Shabbir, who raped the complainant's daughter. Full stop. When the mother of the complainant, namely Asharfi Begum, went to trace the daughter of the complainant, full stop, she heard the shrieks of the daughter of the complainant. Full stop. On this, Ishtiaq and Asharfi Begum reached the spot and broke open the lock of Shabbir's house, and from there, Manisha, aged about 12-1/2 years, was recovered. I have heard learned counsel for the revisionist and the learned AGA. Full stop. The revisionist claimed himself to be a juvenile under the provisions of Juvenile Justice (Care and Protection of Children) Act 2000 hereinafter referred to as the Act. Full stop. Perusal of the record shows that the revisionist was declared juvenile, YD order dated 3/4/2014, full stop. There is nothing on record to show that this order has not attained finality, full stop. The bail application of the juvenile Shabbir was rejected by the Juvenile Justice Board on 15/4/2014, against which appeal was filed before the Sessions Judge, Bulandshahr, which appears to have been transferred to the Court of Additional Sessions Judge, Court number 3, Bulandshahr, who dismissed the appeal, YD order dated 6/6/2014, full stop, para. It is contended by the learned counsel for the revisionist that in the present case, the revisionist has been declared juvenile by the principal judge, Juvenile Justice Board, and, thus, he is entitled to bail under the provisions of Section 12 of the Act, but the learned Juvenile Justice Board and the learned Additional Sessions Judge, Bulandshahr, have refused bail to the juvenile without considering the provisions as laid down under Section 12 of the Act, full stop. He has argued that no plausible and valid reasons have been given for refusing bail to the revisionist, full stop, para. The revision has been opposed by the learned AGA, who has submitted that the offence committed by the revisionist is of a grave nature and he is released on bail, he would come in the association of criminals, full stop. Thus, the revision is likely to be dismissed and the revisionist may not be released on bail, full stop, para. For the purpose of bail, provisions of Section 12 (1) of the Act needs to be quoted, comma, which reads as follows: colon para code within bracket 1. When any person accused of a bailable or non-bailable offense, comma, and apparently a juvenile, comma, is arrested or detained or appears or is brought before a board, comma, such person shall, comma, notwithstanding anything contained in the Code of Criminal Procedure, comma, 1973 in bracket 2 of 1974, or in any other law for the time being in force, comma, be released on bail with or without surety, but he shall not be so released if there appear reasonable grounds for believing that the release is likely to bring him into association with any known criminal or expose him to moral, comma, physical or psychological danger, or that his release would defeat the ends of justice. Full stop.